If you're navigating the complexities of probate in Florida, you're likely facing a mountain of responsibilities. For many personal representatives, the biggest and most stressful question is, how do I sell real estate that's tied up in the estate? The pressure to get it right for the beneficiaries can feel immense. This property could be a cherished family home filled with decades of memories, a valuable investment property, or even a parcel of vacant land. Each type presents its own unique challenges during the probate process. Selling real estate through probate isn't as simple as a regular sale. It's a court-supervised process with specific legal steps, mandatory oversight, and strict rules about when and how heirs get their share. One wrong move can cause significant and expensive delays for everyone involved. That's why today on Clear Probate, we're going to demystify it all. We'll walk you through everything you need to know about selling real estate in Florida probate in 2025. You'll learn why real estate is such a critical part of probate, the exact steps to sell property, from getting authority to closing the deal, when court approval is absolutely required, how long the process really takes, and the costly mistakes to avoid that could derail the entire process. And we'll share real-world examples of families who've gone through it. For many families, the home isn't just a building, it's a lifetime of memories, and often the largest financial asset in an estate. This combination of emotional attachment and monetary value makes real estate one of the hardest parts of the probate process. Why? Because heirs often disagree. One heir wants to sell for a quick financial payout, while another wants to keep the property for sentimental reasons. These conflicting desires can bring the entire process to a halt and strain family relationships. Furthermore, homes carry debt. Mortgages, property taxes, and insurance don't stop after death. Add in upkeep costs, and these expenses can quickly drain an estate's value while it sits in probate, creating urgency and stress for the family. And you can't just sell it immediately. The property legally belongs to the estate, not the heirs. The court must grant the executor authority to sell, a step that ensures all creditors are paid but adds significant, often frustrating delays. In Orlando, a widow left her home to 3 children. 1 wanted to keep it, 2 wanted to sell, creating a stalemate. The probate court intervened, requiring an appraisal to set a fair price and a motion to sell. The court's order to split the proceeds added months to the timeline, but it provided an impartial solution and ensured fairness. If you inherited a home with siblings, would you keep it, rent it, or sell it? Comment below, we'd love to hear. Selling real estate during Florida probate isn't a typical home sale. It's a court-supervised process. Understanding these steps is crucial for a smooth transaction. Let's go step by step through the process of selling real estate in Florida probate. Step 1. Open probate and appoint executor. The process begins by filing a petition to open probate. The court then appoints a personal representative or executor and issues letters of administration. This crucial document grants legal authority to act for the estate. Until it's issued, no one has the legal authority to sell the home. Step 2. Inventory and appraisal. The executor must list the real estate on the official probate inventory and file it with the court. A professional appraisal is also required to establish fair market value. This gives the court and heirs a clear official picture of the property's worth and ensures transparency for everyone involved. Step 3. Get court approval, if required. In most formal administration cases, the executor must file a motion to sell. The court reviews the request to make sure the sale is in the best interest of the estate and its heirs. The court approves the sale to make sure heirs' interests are protected. This step is only bypassed if the will specifically grants a power of sale. Step 4. Hire real estate agent. The executor can list the property with a licensed agent. It's important to use someone familiar with probate sales because there are extra steps, unique timelines, and specific contract addenda required by the court, which a specialized agent will understand. Step 5. Accept offer and file motion. When a buyer makes an offer, the executor accepts it contingent on court approval. The contract is submitted to the court, and interested parties are notified. Some sales require a hearing for final approval to ensure the terms are fair. Step 6. Close the sale. Once approved, the sale closes like any other. A key difference is that proceeds go into a dedicated estate bank account, not directly to heirs. This account is used to manage all the estate's finances. Step 7. Distribute proceeds. After all of the decedent's debts, taxes, and administrative expenses are paid from the estate account, the remaining funds are distributed to the heirs according to the will or Florida's intestacy laws. Following these steps carefully ensures the property is sold legally and efficiently. This court-supervised process protects the estate's value and the rights of the heirs, leading to a successful final distribution. Many families are surprised that selling a home in probate isn't just a private decision. In Florida, executors usually need court approval before selling real estate. The court checks that the sale price is reasonable and protects heirs. If heirs all agree, the process is faster. If heirs disagree, the court decides. Proceeds must flow through the estate account before distribution. In Miami, an executor accepted a cash offer below market value. One heir objected, saying it cheated the family. The judge required a new appraisal and rejected the first sale. The property was relisted and eventually sold higher. This added 4 months but ensured fairness. So how long does it take to sell a house in probate? Here's the typical timeline in Florida. Weeks 1-6, open probate, appoint executor. Months 1-3, file inventory, get appraisal, list property. Months 3-6, market the property, accept offer. Months 4-7, file motion for approval, wait for court. Months 5-8, close sale, deposit funds into estate account. Months 6-12, pay debts, distribute remaining proceeds. Total timeline: selling real estate in probate often takes 6-12 months depending on the court and market. Trying to sell before probate opens. Executors need legal authority first. Skipping appraisal. Courts and heirs need clear valuation. Not communicating with heirs. Surprises cause disputes and delays. Accepting low offers. Judges may reject below-market sales. Delaying filings. Every late motion adds months. Mixing funds. Proceeds must go into estate account, never a personal account. In Tampa, an executor deposited $50,000 of sale proceeds into their personal account temporarily. The court discovered it, froze the funds, and required accounting. That mistake delayed probate by 6 months and created mistrust among heirs. Case 1. Smooth probate sale. Mary's executor listed her home with a probate-savvy agent, kept heirs informed, and got court approval. The house sold in 5 months, and probate closed in under a year. Case 2. Disputed probate sale. John's estate involved a Miami condo. 2 heirs wanted to sell, 1 refused. The court ruled the sale was in the estate's best interest. The dispute added 8 months. Case 3. Out-of-state complication. A family in Jacksonville discovered their father also owned a condo in Georgia. Ancillary probate was required there before funds could be transferred back to Florida. Timeline: 20 months total. Hire a probate-savvy real estate agent. They know the paperwork and timelines. Keep heirs updated. Regular communication avoids fights. Price realistically. Courts reject unfairly low offers. File early. Don't wait until deadlines. Track expenses. Keep receipts for taxes and court review. Stay patient. Real estate sales and probate always take longer than expected. Selling real estate in Florida probate can feel overwhelming, but when you understand the process step by step, it becomes manageable. Remember, the executor must be appointed before selling. Court approval is usually required. The sale process often takes 6-12 months. Communication and preparation are key to avoiding disputes and delays. If this video helped you, subscribe to Clear Probate and let us know your thoughts in the comments. We read everyone. Here's my final question. If you inherited a home through probate, would you want to sell it right away or hold on to it for the family? Share your answer below.